friend Amabawa. Pacho meni ena edimi abedru haisi. Na pimples bi esi meni echi. Ena medical hospital. Na me call in doctor na city so yem operation. Nti o yem operation no. O ya me first one no anyi ena second one so bi ebi. No so ye ya anyi. Na me ne mo ka say meni no aseya na ye ho hwia enyi. Na my bread ewe ni no my bread pa so me nyanti akọ ewo me ni no enti nia na ma page mo koi echi akwan na mananti aba say me hiamoa omommoa me fi se ni obi obeboa me ewo me ni no na me se omommoa me ewo me so me dey go hospital no say obi no operation enti operation no twa me ni echi eyo the operation nti o ye first one no anye ye second one no san friend say this o san ye biem na o ye biem no first one ye le bugu mu e ma tokuro be to mani no nti second one no say obi twa mani echi no dia ye plus ayi atale mani na chi ama e tokuro na da ho no echia o ye ne so anye ye nti o he na na me ade ne keka ko ne keka ko aji no no ankasa refer me odi ka refer me techiman na me ko techiman no almost in Kushia, a brofu free outside the bar. Nikushia almost one part. Brunina wine, many press and who say, many uncle Yinana, or to me, refer and not touching from say, on Shenny. None besides Saturday no say, Doctor Wine a yemen, none more Doctor Niddy. No, besides Miss Anyone, and I'm not so say I made a number and a man. And not Fred Doctor, no, children, I didn't children, and wine a man, a quine say, on Yemen, Missa. Ain't you wine, Shemet? Palampo or mamma, pink lamp or mamma, mamma, won't tell me no, or mamma, semi sign from doctor, no yemen, on one who knew quite or pass to yemen, no one pass up on your answer, no one signs any. If I have doctor, say, my body charge, it's one shemmy, I'm back, one shemmy PM, and no jimmy. And the channel, still none when you are not yet, medical no more refer me of one notch, medimeno ever of a notch. Doctor, no, and you to say, why am from Swan and Design and say. Now operation there answer will be operation no woni madwuma mpo answer why operation they want to be pity prepare any operation tell say me there na ohu mi say 7 previous and nya nipa bi wonani so enti won ti me ni ngina kra en kasa me yes me ne be kasa na wa shout to me say me pharmacy me free na ni nko me kwa wa ahyase na me kwa ye operation na e ko ba say mani no ne aduru no aye den ama no me kwa wa wo fi me enti o de me koma a wo ma o mumia kuro omunya ni hu adwuma so omumia omuso ntimi mia kuro no nti yakoba ase me yankasa me kodra so na makoto mi nuru na makomia mani no ewufi cho mani na ase ye prim kura eni no otwitwa ntimi nya ma ye pa ntimi no e ma kene da mama so ye pa ntimi miru e na me ka sai mani na prim a mani no enya adwuma bi ba ko so kura aka no ehu ade papa ha me sa ade san ni mu kwan. I'm from Machawa, Mia, Mabisa, Namabaha, Miss Remo, the Pamucho. New Pia, since you have no more Casa Crano. The Missy Carmen, the Sherman, intimate Miss Remo, I need you find some more money. Now, Moncama send me, mammy. Then you knew you have a Camas and mammy.
The chilling experience of a woman who had gone to the hospital to seek help, to seek aid, about a condition she thought the medical doctors could easily handle. And this is where it ended up. She ended up losing an eye. Tonight, you're welcome again to another edition of Fact Sheet Live on e.TV, live on Facebook, Twitter, and Instagram. We are discussing a conversation we started somewhere last 2 weeks, and by popular request and from other incidents that we have witnessed throughout the week and the past week, we are revisiting the issue of medical malpractice in our country, what it entails, the rights and responsibilities of patients when they visit any medical facility. The last time I was here with Mr. Kwame Bobe Apia, and he educated us about our rights and responsibilities, the responsibilities that the medical facilities, the medical professionals owe towards us when we visit any medical facility. That's where our focus is. But what really are we talking about? How do you identify that there has been a medical malpractice? How do you see that this matter requires further attention? If you do feel that this matter requires further attention, What are the processes you'd have to go through from the administration of that facility to maybe seeking legal aid in the matter of seeking justice? How do we protect ourselves, and how do we know what to do and what not to do? These are the issues we'll concern ourselves with tonight, live on e.TV on Fact Sheet. Here, if it's not a fact, we don't discuss them. My name is Samuel Eshen, and I welcome you to the show tonight. We're taking a short breather. When we come back, my guest is Mr. Kwame Bobe Appiah, and we'll have a conversation about identifying what a medical malpractice may be and the steps you'd have to take to remedy the situation. And you're welcome back to Fact Sheet live on e.TV. Tonight, my guest is Mr. Kwame Bobe Appiah, and we are talking about the issue of medical malpractice in our country. There have been instances where people have been to medical facilities and don't return the same way they walked into those facilities. And last 2 weeks, we started talking about the rights and responsibilities of every patient when they enter into any medical facility. The patient charter was explained to us as what we ought to do and what we ought to do when we go to various medical facilities. Mr. Appiah, good evening.
Good evening, Sammy.
All right, so for the benefit of our viewers and listeners who may not have followed what we discussed the previous 2 weeks, I think it would only be appropriate if we recap what we discussed the other time, as in the patient charter you explained to us. Then now we can come to the substantive matter of identifying what a medical malpractice may be and the steps that one would have to take. So just recap for us the things you shared with us when it comes to the patient's charter and our rights when we enter into any medical facility.
Well, so last 2 weeks we were talking about the patient charter, and then I gave a preamble to what the charter means and what it's been designed to achieve. I think in recounting, we spoke about the fact that the charter is a document that has been designed by the Ghana Health Service itself to help patients understand what their rights and responsibilities are when they are accessing healthcare within the country. And we started by talking about the rights of patients in terms of access to quality basic healthcare, in terms of their right to information and to know the identity of their caregivers. We also spoke about the fact that they have the right to alternative sources of treatment, and also to have an idea of the policies and regulations of the facilities they attend. And then most importantly, to be explained to the giving information about the kind of ailments they present with to the facilities, and then their treatment plans and management that the physicians or the health practitioners would want to put them on. And then we went further to look at a bit of the responsibilities of the patients also, in terms of what role they have to play in ensuring that they get the best outcome in assessing healthcare, and the fact that they were also responsible for adhering to whatever information and directions they might have been given by these practitioners.
So what are my rights if I walk into a facility now?
So the objective of walking into a facility is to assess healthcare. And so what you are interested in is the best possible outcome that you would have. You are entitled to ask questions as and when the need arises to get the full disclosure and the needed information on your body. I mean, that's the most critical thing, because you can't walk into a facility not knowing what is going to happen. I mean, how they are going to handle you, how you are going to be treated, and then how you are going to be given the best standard of care. So that is the basic right everybody has when you enter any facility, to ensure that those rights are, given you in whichever way you want to assess it.
All right, now let's come to the issue about medical malpractice, because that's what brought us, for us to understand and appreciate the concept of the patient's charter. What is medical malpractice?
So medical malpractice is a legal cause of action when, as a result of the negligence of a medical practitioner, a patient gets injured or the patient dies. So basically, it's a form of negligence that pertains to specific licensed group of professionals. So in the event where the practitioner does not adhere to set protocols or standards in the profession, and as a result of that deviation, something goes untoward, leading to an injury to the patient or a death of that same patient, then we can say medical malpractice has occurred.
Now, that sounds a bit simple for me to appreciate, because then how do we differentiate between a case of a medical malpractice and a case of a patient actually dying naturally during, let's say, an operation, and then the patient, does not respond to the treatment and dies, and then a situation where it's as a result of the fault of a medical doctor or a nurse, and then that patient dies? How do you distinguish between a malpractice and something which is not a malpractice in the line of duty?
So, in talking about malpractice, specifically medical malpractice, there's a sequence of events that will lead to medical malpractice. The end result should be an injury or death to the patient. So we are talking about negligence here, and as I alluded to earlier, negligence in the medical field and specifically in a medical profession, which is malpractice. In proving malpractice, you always tackle it from the end to the beginning, because the resultant effect of the actions or inactions of the practitioner is what we are looking at, or what we are questioning now. So to be able to assess whether medical malpractice has occurred or not, there are stages that you need to go through. One is to establish a duty of care that the facility or the practitioner owed you. Because like I said earlier, when you're assessing healthcare, your utmost interest is to be sure that you are giving the best quality of care. So number one, you need to establish the fact that the facility or the medical practitioner owed you a certain duty. And if that duty is so established, then we go ahead to look at whether that duty has been adhered to the latter, or there has been a breach in the performance of that duty. So if there's been a breach in the performance of that duty, obviously it will come with a consequential effect. So then we go further to assess whether the breach has caused any form of damage or not. I mean, if there's a breach of duty, it would lead to something else. You can't just breach the duty and go scot-free, because the duty basically is what determines the standard that the practitioner owes you. So if that is breached, obviously there has been a deviation from that set protocol, which would eventually lead into something quite injurious. So if you're able to establish that the resultant effect of that breach that the practitioner owed you is the injury that you have suffered from, or the death of that patient, then we'll go ahead to look at the damages that has come out or that has arisen as a result of that breach. There can be an occasion where there would be a breach of that duty of care, but that breach will not result in an injury. So for example, there have been situations where somebody dies, and then people allude to the fact that the practitioner might have been negligent in exercising his or her duties or performing whatever functions he or she had to do. But then it could also be on the other side that the patient would have died anyways, depending on, the condition the patient came in with. He or she would have died irrespective of whatever the practitioner did. So there should be that connect where we're able to ascertain and determine that it is as a result of that breach, the action or inaction of that person or the practitioner, that led to the death of that patient. So until there is that death or that injury, you can't trace back to really determine where that error or that deviation occurred for you to be able to make a claim in medical malpractice, or even to place liability on the performance of a practitioner.
You may have an understanding of the processes and an easy identification of a medical malpractice. But for instance, I take my sister, my brother, to a medical hospital, and then maybe there's an issue. They treat the individual, person dies. How do I know when, for instance, I don't have the folder of my sibling that I took to the hospital, when I don't have an appreciation of the gravity of the issue to understand whether my sibling was going to die with or without the medical attention? How do I know that this case, there's a case of medical malpractice somewhere in there?
So there's always a starting point. And the starting point is your suspicion. So that's why we always say that it's an allegation. You can only allege, because until proven otherwise, it remains an allegation. So if, for example, if there's somebody that has no idea about medical issues, there's somebody that knows nothing about legal issues, all you can say is that your suspicion is that the person might have died as a result of somebody's negligence. But when you are the patient yourself who have suffered the injury and can attest to the fact that during the processes this is what they took you through, and as a result, you have an injury. That is when we go back to the rights that are available to the patient, and also to look at the established protocols to see that there has been a deviation from that protocol. So it is a painstaking investigation that has to be conducted. And mind you, the test for medical malpractice is an objective one. And by objectivity, what I mean is that it is only somebody that possesses a similar skill that can say that this person had done something that is out of the norm. So for example, if there's a case in court involving a medical malpractice case in court, normally they will do what they call the expert opinion, or somebody to come in to give an opinion to say that this is the way it should have been done. And for the fact that this person deviated from the norm, this wouldn't have happened. So for you to be able to ascertain, you only need to be able to prove your injury, that I came here in this condition. For example, say, let's for emphasis purposes, somebody walks into an eye facility with
Let's use the case of the woman we featured before we started the conversation,
okay, sure.
where she walks into a facility with a pimple or something on the eye, and then she ends up losing an eye.
Sure.
Yes.
So obviously, before any physician touches you, they would have done a lot of assessments, a lot of evaluations and all that. But in those preliminary stages, mistakes abound. They might have a wrong judgment, and that judgment will lead to a very, very serious effect at the end of the day. Looking at the video we just watched, the lady claimed that she had a pimple-like swelling on the neck or the eyelid.
Yeah.
Let me put it that way, on the eyelid, and the physician or the doctor decided to operate on it. And so we go in there to investigate what actually it was. Was it something that they had to operate on? If they did, what was the procedure they used? There are occasions where certain parts of the body demands that you do a grafting process. So there are different procedures, different approaches. So for example, if whichever doctor looked at her case decided to use a procedure that is not approved or that is not a standard, and it led to what the condition that she finds herself in now, then we can start the process for investigating what preliminary investigations were done, what laboratory works were carried out, what samples were taken, were there biopsies, were there other, for example, imaging to find out the nature, the size of whatever there was. So all these are processes that we go through to determine that a step has been made, and that could be quite critical in determining or evaluating the process to be used. From the narrative she gave, it is quite obvious that she went in there with quite a good visual acuity. Obviously, there wasn't any impairment. So the question is it the case that you worked into a facility with no visual impairment and you come out losing an eye? Does it in itself put liability on the facility or the practitioner that attended to you? So you can't just claim that just because I came in here in a condition like this and I'm coming out with another condition, you are liable. There are processes. We need to investigate, we need to ask questions, we need to look at your information on your folder and whatever necessary or additional information we might need to be able to come to a conclusion and establish a prima facie case that indeed somebody hasn't done something right. And that is the result that we find out.
We will come to how expensive or inexpensive this process might be. But I'm trying to understand the case of the woman and the initial processes that are available to her, even without recourse to an external entity like your entity. What processes do I have to go through? If, for instance, I feel that there's been a medical malpractice when it comes to a patient who has gone to a facility, what are the processes? So
there are requirements. There are key requirements in making a claim in medical malpractice. The first requirement is to report to the facility where you have a suspicion of something bad going on. So for example, you can visit a facility A and then in your estimation you go back injured or having a complication of a sort and you don't report back to the facility but then decide to go to another place and then wait until a certain time that you think this is the time for me to go back and tell them that, look, when I came here the last time you did something wrong and I got injured. The moment that happens, there is a way they can run away from liability, in a sense that if they did something untoward and then you go for another person to also touch you or also administer a different procedure, then the chain of causation gets broken, because at the end of the day, who bears the liability? the extent of injury you might have incurred from the first facility might have been aggravated because of another person's ideologies or whatever approach he or she thinks would have to be used in correcting what has been done. We should also bear in mind that some of the injuries are irreparable. I mean, they cause irreparable damages to people. So then obviously there's nothing that can be done apart from the fact that you live in whatever condition you find yourself in. So the first requirement is to go back to the facility where you suspect that the negligence might have occurred, to report to them, bring to their notice that when I came here, this is that and that and that happened, and I suspect that the procedure you used wasn't accurate or it wasn't the right way. The medication you gave me was probably expired, you gave me overdosage of something, or the quality wasn't good. Whichever, you see, medical malpractice in itself is quite broad. So it's subject specific. I mean, you can't just slam them together and talk about them. But then as and when the issue, so for example, somebody goes to a facility and then they are supposed to conduct certain investigations before administering certain drugs. So somebody says he or she reacts to sulfur, and then they give the person medication with sulfur, and the person suffers from, say, Steven Johnson's disease. So then you see the person's skin peeling off and all sorts of things happening. You just obviously have to go back and let them know that I am suffering from this condition because of what you gave me. But the whole thing is that person or that patient might not know at that time that the reaction he or she is experiencing is as a result of a certain medication that might have been given, whether in terms of the type of medication, in terms of dosage, in terms of quantities or whatever. I mean, so these are critical issues that needs a proper evaluation by somebody that has an understanding of how medical malpractice comes about. So then after reporting to the facility, obviously, if they are minded, they would want to grant you that audience and then, I mean, give a full account of what has happened. And if they want to conduct further investigations, because it's not the whole facility that might have done that, it's a practitioner within the facility. But because of issues of vicarious liability, the facility should be the one to face the issue and then talk about it. So that's a key requirement. After that has been done and the facility wants to admit liability, then they can get into settle the negotiations with your, I mean, compensation, to talk about how they can compensate you for whatever injuries you might have incurred. But if that does not happen, then the right to, I mean, seek legal redress becomes the next option.
Now, how prevalent is this, situation we are discussing? If you have any data in terms of how this frequently happens?
So far as I'm concerned, I have not chanced upon any documented statistical information in Ghana per se. But then I can, based on the narratives that comes out every day. I mean, you hear them on the radio. Some of them might not have any substance though. But then many a times, it's quality information that comes out. Listening to information that comes out, and by virtue of what we do at our organization, I can say it's quite rampant. It happens almost every minute elsewhere. So it's quite rampant. And the incidence is quite scary also.
Well, the issue I'm thinking about is the remedy the medical facility may decide to give the person who might have suffered some form of medical malpractice. And the cover-ups that may happen. Are there instances and possibilities where medical facilities try to cover up for medical doctors who may have misconducted themselves in the course of treating a patient?
Yes, it happens every day. Because most of the practitioners have this belief that if they don't cover up their colleagues, the next moment it might be them. So obviously, if they have a chance to, I mean, bring in a milder way of, I mean, talking about what has happened, they always take the opportunity to ensure that they don't plunge their colleagues into trouble. But you see, the interesting thing is that when you have a good case, you have a good case. It is not so difficult to lead evidence to also, because you see, the court in its wisdom will give you the opportunity when you're not satisfied with an account of an expert that comes in to give a testimony. You can call as many experts as you want. So it can be the case that the facility, the dangerous part is when they alter your records to, I mean, correspond to your current situation. For example, when you go to the facility and they are charging you at the charge section where they take your vitals before you even go ahead to see a doctor, you might not even be aware of what they are writing. They only just put some equipment somewhere, then they record. They put something somewhere, they record. You might not understand. It has a purpose. It is something to give the doctor an idea of what you are presenting and your condition in which you came to the hospital. For example, if something goes bad at the end of the treatment and they would want to cover up, the easiest thing for them to do is to pick your folder and alter whatever information, to relate to that thing. But because the procedures that are set down, if you, the patient, has been able to give an accurate account of what has gone on in the process, unless of course maybe you are in an unconscious state or you virtually doesn't know anything about your own self in terms of your health, and for that matter cannot give an account of how you felt and how you are feeling now. But if you're only able to say that I went to the hospital whole and I'm coming back this way, we will be able to interrogate and find out what might have gone wrong. And because the functions of these health practitioners are interrelated, sometimes it might not be entirely the fault of, say, for example, a doctor, but it could be from a biomedical scientist. Maybe the kind of investigations they were supposed to do were not carried out properly. There have been situations where facilities even have expired reagents. So, for example, you go to the lab, they take your sample, they put the reagent on it to run the test. The reagent in itself is not good.
Yeah.
So then obviously whatever result that comes out would be in a bad shape. The doctor would also, because he is not a biomedical scientist, would rely on the information that's been given by the biomedical scientist and also make certain prescriptions for you. The end result is that you suffer some form of injury. So then it is going to be the job of the expert to go back and trace what might have gone wrong. And there's always a basis for comparison. If you know what your staff is, you will have a way of ascertaining whether the right thing was done or not.
We'll go for a short breather. When we come back, we'll ask a very simple but very important question when it comes to medical care in this country, and that has to do with your data, the information, the records about you when you visit a hospital. Who owns it? It is you? Is it you? Or the medical facility that owns that information? The records in that folder, should you have access to that record or you should not? Then, how expensive or inexpensive are these processes if one is seeking for a remedy when it comes to some medical malpractice that would have happened to that individual? But if you just join us, this is Fact Sheet live on e.TV, and you're welcome to the conversation. My guest is Mr. Kwame Bobe Apia. He is the Executive Secretary, Advocacy for Medical Malpractice Victims, and we are talking about these issues because some people were asking on social media who you were, and very much interested in the submissions that you are making this evening. We'll take a short breather and we'll be right back. Welcome back to Fact Sheet live on e.TV. We are discussing the issue of medical malpractice in our country. Cases where people walk into medical facilities with small medical conditions and leave with huge medical problems, sometimes losing their lives. But the lingering question is, that data, that information, that record of all that I've been going through from the moment I entered into a medical facility, who owns it? Should the patient have access to that information? Mr. Pierre, the data, who does it belong to?
So the data is basically information about the patient. Without the patient, there is no facility. Without the patient, there is no physician. So in this particular dispensation, the patient is the most important person in all this discussion. So why wouldn't you want the patient to have access to information about him or her own self, not any other person? What it is that in any circumstance that a patient would have to have access to information in his or her folder, you need to make an application. No facility can deny you information about your own self. But for purposes of continuity, in the event where a patient goes to the facility and the folder is handed over to the patient and the patient is unable to keep it safely, what it means is that there's going to be a discontinuum in terms of accessing healthcare. And that is one of the reasons why the facility would want to keep the folder. But the content in the folder is that of the patient. So normally what happens is that you can write or make a requisition for a medical report to be given to you. So when you make a request through writing, normally addressed to maybe the medical director of the facility or whoever is in charge of the facility, they would also refer to the attending physician, the one that has been seeing the patient, and then that person has the obligation or is under obligation to write the report. I don't know, maybe depending on the facility you find yourself, maybe some of them might request for some amount to be paid. Others probably might just write it depending on the nature or the extent of information that you might need. But then the patient has access to whatever information. And I think when we're even talking about the patient charter, we mentioned the fact that the patient has the right to information about him or herself, the treatment plan that they are going to put the patient on, and the management and all that. So by virtue of that provision in the patient charter, which is an inalienable right of that patient, you have the opportunity to request for information on your own self.
With your admission of the possibility of doctrine of information or records, especially in cases where medical malpractice would have happened. If I, for instance, go to a facility and my records, let's say, being, careful, I decide to take shots of my records as the doctor's writes in my folder, keep it on my phone. Would it be tenable if I decide to go to court and I showcase these records for my folder?
So you can equate this to somebody having a photocopy of his or her folder. There have been cases where people have, you see, in court, the name of the game is evidence. Whichever way you are able to, produce certain kinds of evidence, it's about the admissibility of that evidence. There are certain exhibits that might not be admitted to court. But then, if you're able to claim, once I have already alluded to the fact that you have that right, so it does not mean that, for example, you going in to steal that information. It is your own information. So I don't think any person would want to question why you have information about your own self. Whichever way you got it is up to you, but then at least you've been able to provide information about yourself so far as your health is concerned. So that is also something that is also important for.
Okay, so I take my mother to a facility, her records, do I have a right to take?
You don't have the right to, unless she sanctions it because of confidentiality issues. If any doctor or any health practitioner hands over a patient's folder to a third party and anything happens, they can be taken on legally. So irrespective of whoever you are, you don't have the right, unless in certain circumstances like emergencies where a relative would have to be given certain kinds of information, because the content of that folder is information of the patient. So you don't have the right by virtue. For example, if your mother has an ailment that has not been disclosed to you for whatever reason, do you think it's appropriate for somebody to hand over the folder for you to open and just, so for all this while my mother has been suffering from this and she kept it away from us? She might have a reason for not disclosing. So for that reason alone, you are not under any obligation to get that information without her consent. So if the for example, in your particular case,
but what does consent mean? Does verbal, pass for consent, where I ask my mother, should I open your folder? Can I keep records of it? And she says yes, but there was no third party to have witnessed that conversation that happened. But I know that she said yes, go through it and take pictures of it. Would that suffice?
So consent basically depends on the kind of relationship that you have. People have, or they owe fiduciary relationships with to other people. In the event of your mother and yourself, a son-mother relationship, in any case, why would your mother even be interested in taking you on if you are privy to information? My concern is with the doctor or the practitioner giving you access. So for example, if you want to walk into the consulting room with your mother and your mother tells the doctor that this is my son, this is my only son, I don't care what he gets to know about me, so he can feel free and discuss whatever my condition is in his presence. That is consent that has been given, and that empowers that practitioner to disclose certain kinds of information which you wouldn't have known had it not been the fact that she has permitted them to let you know. So on the blind side of the practitioner, or maybe for example, if you happen to have access to that information out of that facility where that third party relationship is concerned, and it's between you and your mother alone, and she so wishes that you get access to that information, I don't think that is a big problem. But the legality comes in when, by virtue of that confidentiality, provision, the doctor divulges certain kinds of information to the patient's relative without telling the patient that for this reason. So there can be instances where the patient is unable to do certain things for him or herself, and for that reason, the patient's relative would have to be made aware of the condition in order to be able to help the patient in times of need, or for example, when the patient is at home. In such circumstances, there is no other way than to let you know what the situation is, so that you can also adequately support the patient as and when it becomes necessary. But even in such circumstances, the consent has to be sought from the patient.
All right, so I feel I have a case of medical malpractice. I have gone through your initial process of writing to the administrators of the facility to file a complaint. I see there is stalling by the administrators of the facility. I feel injustice may be done me if I don't look for external help. Now, at what point does the external help come in? What are the channels? What are the institutions that are supposed to cater for these issues, apart from a private one like yours that, seeks our welfare? Are there any, statutory institutions that are supposed to see to these things?
So, in terms of medical practice,
yeah,
we have Nurses and Midwifery Council, we have Medical and Dental Council, we have Health Facilities Regulatory Authority, and then a couple of others. But the issue is the level of regulation that, they come out. And then more especially, most people don't even know that when these issues come up, you have the opportunity to make a report to these regulatory authorities for them to also take them up, investigate, and then if there is the need for any sanctions to be meted out, it is done accordingly. But the problem we have had on a lot of occasions is that when they commission investigations to be done, you either don't hear of the report, or it comes out, they shelve it, and it will be collecting dust on their shelves, or even if they make a disclosure of whatever their findings are, it ends there. Nothing is done. So the patient who feels he or she might have been injured in the course of accessing healthcare is not under any obligation to sit and wait for any committee's report. So, for example, if it is going to take a year, is it the case that you sit and wait for the report to be generated? It is the interest of the facility itself to exonerate itself from whatever complaints or claims that patient is making by judiciously conducting the investigations in a very, very speedy way to be able to come out with whatever their findings are, call the patient back, sit with the patient, explain the circumstances that might have gone on to the patient, and then what their investigations came out with. If the patient is not satisfied, he or she has every opportunity to take the matter up to whatever level he or so wishes. So there's no hard and fast rule that states that sit down and wait for them to come out. In any case, the most important thing is to let them know that you have injured me or you have killed my relative, and as a result, I want to take action. If they want to sit with you, they can say, okay, fine. Let us sit and talk about it. We want to find out and even know more for corrective purposes. Because if we get to understand what has gone on, they can initiate some reform processes to reform how things are done at the facility to ensure that such occurrences are abated. But some of them don't mind because they would never want to admit that they are liable. They might be thinking of the image of the facility, that if the issues like this come out, for example, if it's a private facility, most people won't come here because they'll say, oh, this facility, they are killing people, so nobody would want to go there again. So for such a reason, they might want to find every way. And interestingly, most of the people who suffer from, such injustices are very vulnerable. And the vulnerability cuts across, not necessarily financially, unstable, but then lack of knowledge about what is happening, not knowing what to do, a whole lot of issues. So because of that vulnerability, they don't seem to have that courage to face whoever it is that is in charge of the facility. So they are afraid. They don't know what to do next. Why should I even, would they accept me? Would they listen to me? If they don't listen to me, what happens next? So that kind of culture has gone on for a long time. So it's about time we also try to demystify, some of these things for people to understand that the moment you go into a facility, it's a contractual arrangement, and that is why we were talking about the facility owing you a duty of care, because you're also paying them for the service. So you can equate accessing healthcare to any other business venture that you get yourself involved in. The only difference is that at the point that you go into the facility as a patient, you don't have control over yourself. You might have lost some senses. You don't have, everything doesn't work well with the patient, because at a point in time, he or she might be in pain. So that is when you are going to look at the tenets of the law to see what your entitlements are, and then probably to equate it to any other venture. But when all is said and done, and you gain some consciousness or you gain some relief, then you can reflect and look at what has gone on and the end result, and then be able to determine what
in your experience over the years, has there been instances where justice has been served patients who had gone with complaints either by administrators of the facilities in question or any of these statutory organizations like the Midwives and Nurses Council and the rest of them? Has there been instances where sanctions have been brought against facilities and commensurate compensations paid to patients who might have suffered medical injuries?
So there have been instances where settlements have been done, where patients have been given some amount of money as compensation to cater for whatever they might have lost as a result of the actions or inactions of medical practitioners working in various health institutions. The unfortunate thing is normally we are unable, or the patients are unable to evaluate the degree of injury to be able to actually get what it warrants. So, for example, I know of a case where a baby had the arm amputated, and the facility admitted that they were liable, but instead they were going to give the patient, the little baby, 5,000 Ghana cedis. So in this case, what would 5,000 do for such a case? Even if they want to put prosthetic limbs there, it can't even cater for, let alone the unforeseen developments that will come up as the child grows over the period of time. So because of the lack of understanding, and because of the fact that most patients don't know the magnitude of the injuries they suffer, because sometimes the tricky thing is that you might not have the full effect of the injury immediately, almost immediately. It takes time to show itself up. So if you rush into taking just anything as compensation, so we in our language we talk about fair and adequate compensation. If you just run into taking anything, but there have been instances where people have proper representation, legal representation. They go into facilities assessing healthcare, they get injured, they hire the services of lawyers, the lawyers issue rates, the case is on, they are talking about it in court, and then the facility behind, on the blind side of the lawyers, go to engage the patient. So for example, if in the wisdom of the lawyer, the situation warrants such, for example, say 500,000 as compensation, the facility will quickly come and see the patient behind the back of the lawyer and tell them, look, this man is only going to waste your time. It won't yield any good result. Why don't you take this and then let's bring closure to the matter. So it's also something that is quite of a big problem, because they play on the ignorance of the patients to also do whatever. And by the time you realize, the patient might have gone ahead to take the money and the lawyer will be just there not knowing what to do next. So these issues come up. But in terms of issues being settled, it comes up quite often. And then even in court, most cases comes to a logical conclusion, and the patients are fairly compensated.
All right, so I am looking at an outfit that is well placed to do justice to my case. And so I'm looking at an outfit like yours. How expensive, how inexpensive is the process of having professional lawyers like yourself and medical professionals due and interrogate my issue to win me a case in court?
In terms of cost in medical malpractice, it's quite huge. Worldwide. Very, very huge. And it's huge because a lot of investigations has to go on. A lot of legwork has to, be undertaken. And then you need to do almost virtually replay what has gone on to be able to understand what really occurred. And I think that is one of the reasons why people even run away from pursuing matters in the area of medical malpractice, because I think most people are of the view that they might not be able to hire the services of lawyers and then pay for such services. But fortunately, because our organization is a non-governmental organization, we are not actually in to make profit. We don't charge people for services that we render. But the most important thing is for us to be able to establish a prima facie case out of the narrative that the patient will come and give us. Because if you come and tell us a story that we can't, differentiate the head from the tail, there is no way we can be in a position to assist. and that would be a cost to whatever we are doing, because at the end of the day, we might have wasted time in trying to seek justice without getting the fundamentals right. So we always try to do a lot of advocacy, trying to educate patients on what they have to look out for, so that in the event something goes untoward, you can give an accurate account of processes that have gone on. That will help us, because it could even be the case that something might not have been documented in your folder, even if you have the folder unaltered. I mean, when it's not being touched, it could be that there might be omissions, which might be critical in determining whatever case that the patient comes up with. So it is important that the patient empowers him or herself and try to get a better understanding of why he or she is in the hospital, what they are doing to his or her body, and then what the consequences are likely to be. And that is why normally we talk about informed consent in situations where the physician wants to touch your body and carry out certain procedures to let you know the repercussions of the processes they are going to do on your body, so that in the event something comes out, you already might have been in the know that there's a high likelihood that you might suffer a certain fate after certain procedures are carried out. So all we need is a good account, and then we'll pick it up from there.
Now, final question before we sum up our conversation. If you are an NGO and you don't take upfront money to do the work, and you have already admitted it's expensive, you have also admitted that it is usually the vulnerable who fall prey to some of these medical facilities. How then? Do you do your legwork? How then? Do you get the money to get your medical doctors to give you the expert opinion before you arrive at your conclusions to go to court?
So because of the sensitive nature of medical malpractice, and you see, I call medical malpractice a silent epidemic. I call it a silent epidemic because it's killing people silently and people don't know. There are people who also think that, well, they have some financial strength to assist in. There have been instances where victims, alleged victims of medical malpractice, come into our organization to tell us what they have gone through. And they have even relatives coming on board, coming with them to try and support what we do. So we are still in the process of engaging people to get sponsorship, to get funding, and to get people who really, buy into what we are doing to help us put a formidable organization up. But in the meantime, we are finding ways and means to foot our activities, and I'm sure eventually we might get people to come on board to assist what we do.
Let me read 1, 2, 3 comments that have come through before we end the conversation. So Malik says, I'm enjoying the conversation. I never knew some of the things you guys are talking about tonight. Thanks for the information, Malik. We are happy that we've been able to save you some information. This one also says, and it's from Sarah. Sarah says that I am being well informed today. Is it possible I could get the number of the doctor in the studio? I'm sorry, but he's a lawyer. Somebody's looking for your contact. This one says, could you kindly get the man to give us a bit more information about his NGO and what they do? I am interested in meeting him. So a few comments about you and your outfit. If, for instance, people want to get in touch with your outfit, how do they get in touch with you?
So we'll put our telephone lines out, and then so that's a starting point. When they call us and they tell us what their story is, we work across the country. We're everywhere. So depending on where the case comes up, we have representatives who will pick it up, do the bit of investigations that we need to do, and then so we have what we call the review panel. We bring it back to the office or whichever place that the issue has gone on, and then they would, based on their professional expertise, do an evaluation of the narrative that the person has given to be able to determine that something has actually gone untoward. And then we'll pick it up from there in consultation with the patient to determine the next line of action to be done. So we'll give our telephone lines out, and then talk to people who have issues to be attended to, and then we'll see.
Are we getting the number now, or we can proceed and later on give the
Sure,
number?
I can give it out now.
Yeah, you can give the number.
So we are working with 2 main lines. One is a Vodafone number, and it's 0500 213232. 0500 213232, and the other is an MTN number, 055 255 7665. So these are 2 numbers that we work with, and it's on 24/7. Anytime there's any need, we will be there to assist.
All right, and the name of your entity again?
So the organization is called the Advocacy for Medical Malpractice Victims, AMMV.
AMMV. They are also on social media as well. Your handle?
So, Advocacy for Medical Malpractice Victims on Facebook, and then my AMMV on Instagram. And then, yeah, sure, the two of them, yeah.
Okay, so that's how you can get in touch with them and have a conversation with them. If you do have a case of medical malpractice and you need your assistance to push it further, I'm sure they will be ready to assist you. But I've been here in the studio with Mr. Kwame Bobe-Appiah, and we've been talking about medical malpractice. We had the conversation about 2 weeks ago, and by popular request from the very many emails and text messages we received from you, our viewers, we decided to, continue with the conversation and look at other angles as we have discussed tonight. And so we'd like to thank you, Mr. Appiah, for making time to join us tonight and
thank
for
you, Sammy,
the education you have given us.
You're welcome.
On that note, we'll thank you for being a part of our discussions tonight. Go in tomorrow, there will be a replay of the show live on e.TV at exactly 10 a.m. We encourage you to tell people about the story so others would also get informed. My name is Samuel Chen, and on behalf of the production team, we say thank you and good night. Mercy B and the team are ready to serve you the best when it comes to issues that pertain to your health, your relationship, and many more. Do stay with us.